can be really put down to mental health issues.
Yes, very true. Very
A lot of people die by suicide because they reach a stage where if they are properly counseled,
They could have.
they could be brought back.
There are some helplines now
Yes, yes.
where you can
Everywhere,
immediately dial
everywhere.
the number. Helplines are there. But Lordship is right. Young people,
Oh, yes.
mid 30s, 40s.
They know, and that again, my lord, maybe I may not find, my lord, much takers of this view. That's because of, my lord, the family shrinking.
Absolutely.
Because if I am in depression,
Yes.
my brother,
Nobody
my
can
father,
talk with.
Yes.
there is somebody who will push my.
System work very well.
Now a two member, 3-member family, there are no friends, only virtual friends. I have, for example, a person has 5,000 friends online.
WhatsApp friends.
WhatsApp friends, there is no his neighbor also to talk to. These are one of the issues.
But in fact, let's just say in a lighter vein that HUF is only in the Income Tax Act now. my lord.
That's correct. Practically, it is only income.
It is.
All right.
Grateful.
My lord, your Lordship may say, the order says have a joint meeting. My friend can give a date immediately after Dasra holidays, my Lordship.
We the year for that we may not trouble the court. We'll coordinate.
I'm not putting it down.
You are always welcome. Anytime I'll call the officers on that day.
All right. So what is this? 505?
May I just give a brief outline as to how the matter has travelled to the Lordship? So it's
Arbitrator.
the question, my lords, whether an arbitration agreement in a contract which is required to be stamped and registered is not registered and stamped, whether that arbitration clause can survive. Now, my lords, the matter travels like this. My lords, we filed a suit. Work order was issued by respondent to me, unregistered document, unstamped document. In that, there was an arbitration clause. We filed a suit because it involved invocation of my bank guarantee. The trial court granted me ad interim injunction. They filed a Section 8 application. We relying on SMS T and Gurpal, we said that this arbitration clause cannot work. Trial court rejected the application. Against that, a civil revision was filed, kept pending for 2 years, withdrawn, then a writ was filed. We objected that Section 8 order is appealable under Section 37. A writ is not maintainable. The High Court clause by the impugned order said it's not an absolute bar. In peculiar facts, we go by and we filed a review, dismissed. We came to your lordships, and our only argument was that Section 37 is a remedy. 1, 2, SMST and Gurpal say that since the contract is unstamped, the arbitration clause is non-existent. It cannot be worked out. With utmost respect, the matter was closed for judgment in November. Vidya Dhroliya affirming Gurpal and SMS came in December. And the judgment clause, which makes reference, is in January. It holds SMST overruled because Gurpal is affirmed by Vidya Dhroliya. Therefore, Gurpal is now referred to your lordships.
Right.
That is how it is. We never argued all this.
January, so
I have no difficulty.
who is appealing against it?
Because there has been a subsequent development. The direction was to impound the contract and I was supposed to pay. Document impounded, I have paid. My bank guarantee has been in cash, 3.5 crores. And now I have invoked an arbitration with the clause saying that please give me back my money.
But who is appearing as responding? Nobody.
It was contested on first minutes. They appeared.
There is nobody. We may have to consider appointing an amicus. That's why if you don't do it today.
There was a caveat.
We were just appearing for the bank, was not concerned with the arbitration.
In fact, let's.
For that day, there is nobody appearing. There's no lawyer. Nobody is there. You're not contesting.
Let's, they were there in the first round.
There are two.
Was a caveat there.
Charu Ambani and Sanjay Kapoor.
That's right. There was somebody.
There was no, they filed a caveat. It was
They
after.
were fighting KBA. Now.
After recovery, because they've got the money. So perhaps
Leave granted. This hearing concluded, judgment was served.
That is 23rd November. And Vidya came on the 14th of December. And we never had any opportunity of making any suggestions on Vidya.
Why did not brought this actual notice of the court that some judgments are pronounced by the, after the judgment are reserved in this case? Would I make an application to just?
With utmost respect, I tried to file a review application. It was not accepted in the registry. Number one.
Not
Number
review.
two. No. Then I filed an application for modification of the judgment, modification of the order. Not our case.
Regard to the nature of the issues which fall for our constitution in this matter. And also there is none appearing today for the contesting respondent.
One.
We have considered that the amicus must be appointed to assist the court. Facts of this case, we appoint Sri Gaurav Banerjee.
I will supply.
Sitting counsel.
Which I will
He's senior. He is a senior.
Sitting counsel. To assist the court in this matter. The registry will forward the papers to the amicus. And this is case 15th of what day is that we put that imagine that 17th January.
Look, may I have one request? There's an IA which I have.
How long will you take? You must tell us how, depending on how long it takes for you to convince us.
Because according to me, the whole judgment is premised on things that we never argued. Neither of us argued.
No, but once the matter has come to us, we have to examine and decide the issue.
We will.
One for all.
I'll take not more than half an hour because my IA contains all the material, the relevant provisions of the Maharashtra.
Judgments are there.
Everything. Only a compilation perhaps of judgments that I'll take.
As regards registered, unregistered documents also, this principle of impounding, there are two lines of authorities. One is that court cannot look at it.
That's
The
what
other view is that,
impound and then pay
Impound
duty and then
well, yes.
this direction was issued. Our document was
Anyway,
impounded.
so there are two line of authorities in those for immovable property also.
Was never argued. Nothing of this was argued.
I think single half day is sufficient.
More than
More than
sufficient.
sufficient.
More than sufficient. More than sufficient.
We put it on the 6th of December.
6th December. May I have just one more request? There's a IA which is IA number 24652 of 21, which was for modification, but ultimately it was said that this is akin to a review, dismissed. It has all the material. That IA may be taken up and permission.
Make it a part of a compilation.
I will do that. I will do
Make
that.
it.
So let's 2 weeks to file the compilation.
Petitioner is granted 2 weeks available to the court a compilation containing
Containing the contents of IA number 24652 of 21
yes
and all relevant judgments of your lordship.
containing this so and the issues involved.
The issue is only.
You can just put a note because
The issue is, the question is crystallized already by the court drafting the order.
all the details and containing all the details.
Yeah.
So the compilation containing the contents of IA number
24652 of 21 and plus the compilation of judgments,
and all the
relevant judgments.
relevant details.
Give us 3 lawyers, name of 3 lawyers who are very active in arbitration, young lawyers.
Mr. Data.
Data?
Or a manager.
No, Mr.
No, not Data.
Appoint-
Mr. Balbir Singh.
We want 3 young lawyers. Not Balbir Singh is not young lawyer. We want 3 young lawyers into this who are into very active in arbitration. Mr. Banerjee, who are those young lawyers according to you who are very active in arbitration?
Oh, there are quite a few.
You can't select even just now. Give the name.
And he's saying he will select the name.
I'll get hold of it.
Not for your assistance or our assistance.
My lord, Mr.
We
Singh,
want our assistance.
I-
That lawyer.
there are quite a few of them, my lord.
This is also there.
Give us names.
I'll give a few names.
6 December.
6 is.
Very well.
Where are you? 506.
My delegate.
Now, this has some importance for the armed forces. What has happened is, my lord, there was an application for clarification which was filed on behalf of the Union of India pursuant to, my lord, the judgment in Joseph Shine. Joseph Shine, as your lordships know, strikes down adultery. And broadly, my lords, the grounds were that this was my lord, essentially the patriarchal aspect of that provision, which treated women as chattel. Now, my lord, be that as it may, we're not directly concerned with Joseph Shine because that was decided on a different. My lord, we are really concerned with what amounts to discipline or indiscipline in the army or the armed forces generally, and what is unbecoming conduct. Because we have our own, my lord, the armed forces would have their own code of conduct. And therefore, my lords, if what has happened, let me just indicate as to what was occasioned this.
Finding it in the form of a clarification.
My lord, what happened was this was a clarification because what happened was this, my lords. There were certain, officers who were charged for unbecoming conduct on the ground that while my lords, that they were having illicit
Feeling the
relationship.
affection or something. The expression used is.
My lord, illicit relationship, my lord, you may call it an extramarital affair or whatever, my lord,
There's a-
unbecoming conduct. We call it unbecoming conduct or, my lord, indiscipline. So what amounts to that? Now, when, my lord, an officer is serving out there in the field and his family is stationed in the, my lord, family accommodation away from the field, and another officer, my lord, enters into, it may be consensual in nature, but what, therefore, my lord, can we not take action? What has happened is that the AFT took a view in some cases that it must be quashed because now because of Joseph Shine. So, my lord, this would certainly create some instability within our ranks because, my lord, ultimately we have to be able to, my lord, inspire confidence in the officer who goes to serve in the field. And, my lord,
You're saying that they can be charged for misconduct.
misconduct, indiscipline, unbecoming conduct, and, my lords, because adultery has very different patriarchal, my lord, connotations under 497. Now, here under this, my lords, our action we can even take against a female officer. There is nothing unequal or it's completely gender neutral. But so this is the issue, my lords, and therefore, my lords, this has been put before a
So
constitution.
which part of the judgment
Yes.
of Joseph Shine's actually creates a problem for you?
My lord, simply because what has happened
What is it that you're seeking to
My
clarify?
lord, we are seeking to clarify that the Joseph Shine judgment striking down section 497 will not come in the way of the armed forces taking action for under certain provisions, my lord, under our respective acts, including the Army Act.
Does it preclude you from doing it? Does the
My lord,
judgment
what has
say-
happened is the AFT has taken such a view.
But then should you not independently challenge that? I mean, instead of
No, we have
clarification.
We have challenged it, but my lords, it requires some, because my lord, they are using the Constitution bench judgment in Joseph Shine.
Say the Constitution bench is either right or wrong.
Right.
If it is wrong, you have a remedy of review.
No, my lord, we are not saying it is wrong because it said nothing in respect of the army.
That's right, exactly. Therefore, if you say it is wrong in individual cases, if you have challenged it,
We have.
you have challenged it.
We have, my lord,
There-
and the question has been left open. What has happened in one of those judgments, we have
You
it.
can always pursue that, saying that Joseph Shine cannot stand in the way of your, taking action against somebody who's.
My lord, this has specifically been referred to a Constitution bench.
It is said the criminality about adultery
Right, right,
has been done away with.
right, right.
So that doesn't mean that the
Service
conduct
offense.
is, that does not mean that the conduct cannot be treated as misconduct.
Absolutely, which is
By
what we are
employer.
saying. Correct, correct.
Is there any taboo against that?
Because under section 63 and 645, you are referring to
Absolutely.
those.
We are relying on that. In fact, we had charged one of these officers under 45 and the AFT took a view and this is coming up in multiple cases. Yes,
Any kind of a misconduct defined
yes.
has to be examined independently.
That's exactly what we are saying, my
Oh,
lord.
how is it? Judgment will come in your way in taking a
Lord,
decision.
this is what unfortunately the AFT has been doing.
That you can challenge.
Lord, we have
What happened to
challenged
that?
in one of those decisions, my lord, the court, this court,
Yes, relying on this, this was your.
my lord, because my lord, there he had been acquitted, so that was taken care of. But as far as the question on section 63 is concerned, my lord, the issue was left open. So, my lords, what has happened is that this has been referred to your lordships because Joseph Shine is a constitution bench judgment. So, 3-judge bench has referred to. So, my lord may just decide the issue whenever convenient. It won't take very long.
Just 1 minute.
Yes.
Immoral act. Any immoral
Lord,
act
we don't use the.
is not a criminality.
Yes,
May not be a
exactly,
criminality.
madam.
May I submit?
Exactly the issue, madam. Should they be treated as a criminal or just a simple misconduct? That is the only issue, madam.
May I submit?
Lordship has taken away the criminality part from the penalty provision, madam.
That's correct.
But they are still treating them as a criminal, madam. That is the only concern.
No,
That is the whole point. If it is a.
a man may not be, it might be slightly different to say that you should not be punished because the woman cannot be treated as a chattel.
Yes,
And dragged to the court and things like that. You know, in the uniformed services,
yes,
where discipline is of the paramount importance,
yes,
the aberrant conduct, at least as it is understood to be, conduct which involves actually shaking up the life of the officers, because everybody is ultimately dependent on family as a unit for society. And the integrity of the family is primarily based on the faithfulness that each spouse expects of the other. So if this is going to shake up, discipline, the life, the even tone of somebody's life, and the armed forces must have, some kind of, they should have some kind of assurance that they take action. How can you cite Joseph Shine and say that, it cannot be?
May I submit, Willis? I am
Can I
appearing
make
for
one
It's not exactly desirable conduct. See, when you say that it should not be treated as criminality, and it's not a criminal offense, the court is actually, in this particular case, actually taken a value judgment of its own, substituted that for that the legislature with reference to fundamental rights and said it is violative of fundamental rights. Okay, that's fine.
Yes.
But the employer says, you take a case of a private employer, forget about the state. Supposing the private employer has its own view, he says that we will not permit this, and we treat this as misconduct. Treating it as an item of misconduct, action is taken. Can you produce Joseph Shane and say, no, you can't?
Not at all,
ma'am.
not at all.
If you
Shall I make a very
if
short
a private employer can be permitted to do that, then why not stay?
Willis, may I just make one?
Shall I make, Lord, I was appearing for Joseph Shine. But shall I make a very short submission, Lord, in answer to your Lordship's query?
Yeah.
I was for the petitioner in Joseph Shine.
We know that.
I am just making a very short answer to that. As your Lordships were observing, there is nothing for a clarification at any rate. What I am respectfully placing, Lord, as your Lordships were observing, but in Joseph Shine, we only, Lord, challenged the constitutionality of 497 of the IPC and 198(2) of the Criminal Procedure Code. These three sections, or this half a dozen sections, were in the Army Act, in the Navy Act, and in the Air Force Act, were not the subject matter of Joseph Shine. So what essentially happens is, when it is something the respondent center cannot have a case which the petitioner in Joseph Shine did not have. We cannot now expand the scope of the repetition in a clarification application. That's what I am respectfully pointing out, my lord, as your lordships were observing. Now, my lord, as your lordships were saying, if at all in a particular case, well, a defense in the light of Joseph Shine was taken, but it is then for the center or for the authority to prosecute, to pursue that particular case. But one case, but in United States Court of Appeal, Perez versus State of Roseville, but was a case where a departmental action was taken for the alleged bad conduct. Then the United States Court of Appeal decided in Perez versus State of Roseville, but one will have to find out the nexus between the alleged act and his official duty. Likewise, but in our country also, unless and until, my lord, it is agitated in a particular given case, this cannot be decided now. But the Joseph Shine decided only 498, and the Lords may also appreciate one fact. Neither of these sections.
You take the case where there is an enumerated item entering into an illicit relationship with somebody else,
Yes.
and a live-in relationship with another man's wife,
Yes.
amounts to misconduct.
Yes.
Correct. Can you
Yes.
apply Joseph Shine and say,
No, it cannot be. That's what I am also saying. Joseph Shine did not decide that.
that's exactly what you're saying? That
Yeah.
doesn't-
May I just make one
Joseph
submission?
Shine
simple.
did not decide that. It is beyond the scope of Joseph Shine.
It is a simple
Can I
question.
just make one submission?
Yes.
Section 45 and 63 of the Army Act are very clear. If at all any person subject to the Army, Navy or Air Force Act behaves in any manner which is unbecoming of his conduct as an Army officer or Navy officer, Air Force officer, he is likely to be, he is absolutely liable to be punished for misconduct under the 45 and 63. 63 says any officer or any member of the armed forces subject to this act, if at all behaves in a manner prejudicial to Army discipline.
Probably this officer, additional officer,
But
people is concerned about
My lords,
some of the observations in Joseph Shine.
my lords,
It perhaps tends to sort of give the impression
my lords.
that you will be intruding into the liberty and the freedom of the individual.
We will see.
It's a choice.
My lords,
But freedom appears to be to have an illicit relationship.
very well.
You cannot go
To
there.
that, my lords, to that, my lords,
I mean, that cannot.
may I just say this, my lord?
One more
To
thing.
this, my lord,
One-
yes.
Now, in this, suppose is for this sanction, of course, in the light of the decision, he cannot be penalized.
Yes, my lords.
But at the same time, the question is whether he can be subjected to disciplinary procedure.
Very,
In terms of the
That's what,
relevant.
that is what we are trying to answer. We will answer, as your lordship, Justice Vivek Kumar was observing. But what I would respectfully answer to that, Lord may kindly appreciate. But none of these sections,
he cannot be penalized under the provisions of the IPC.
That is different.
But certainly under the provisions of the Army Act, he can be penalized.
that goes without saying. That's what I am also saying. Well, what I am
Madam, I would
pointing out
request you to just wait a minute, please. Just a minute. My lord, what we are saying is that because there is such a large number of cases which are coming up before the AFT has taken a view. Now, my lord, if we keep appealing in individual cases, which of course we have to do, in the meantime, my lord, there are so many disciplinary actions which are being stalled, and it is very dispiriting, my lords, for the officer who is serving in the field. So, my lord, that kind of confidence we have to give our officers.
There the solution is,
Yes.
in one case,
Yes.
the matter is decided in one of those cases where the parties also heard, and this court, if you are going to have a final decision, this court is
I think, my lord,
now.
we are requesting this court because it
But
has
why
already
should we
been
do it in a
referred.
clarification.
My lord,
We think
my
that
lords, for once and for all, it will take care of the problem. It won't take very long, and your lordships may have to go on.
in one of those matters where you are quoting an order against
Right.
you,
Right.
you can challenge it to write, that particular decision with the person also on the party array. So he will have his say. I don't know whether he's here in your clarification.
No, he's not here.
So we are invited
My lord-
to make a clarification in the absence of a person who is going to be affected.
No, my lord, may I put it this way?
Proper.
My lord, we can certainly implead those
Why
parties.
should we-
No, I'm just suggesting this, my lords, because ultimately, my lords, it requires clarification, and this court.
How are you
which are-
here? How are you here? You are here because there is an AFT order
Right.
which takes a view that the employee whom you have charged, charged with misconduct is protected by Joseph Shine. We take it that's your problem.
Yes.
Still.
Yes.
So that order can be independently challenged. Which is why we began by saying whether you say that Joseph Shine is in any way wrong. You say you have no quarrel with Joseph Shine. You say Joseph Shine is fine.
No, because that is the way we are reading Joseph Shine.
That's right,
Which is, yes, that is the way we are reading Joseph
Once you
Shine.
accept that Joseph Shine is
Right.
right, this clarification business I think should not be sorted to.
Well,
It's better that you carry the matter. You will have a final
please
decision.
consider-
The other person also on the party area. You will have a discussion.
No, just give me a minute. Let me just confirm.
That will be better.
Can I just make one submission? Instead of tinkering with Joseph Shine, what my lord said is absolutely the correct way of going about it. Because the person involved in one of my clients, in fact, has suffered 3 months rigorous imprisonment for allegedly having an extramarital affair with somebody else, some unmarried woman. However, my lord, it doesn't fall under the ingredients at all of Joseph Shine or adultery. But what happens is Joseph Shine by itself, my lord, has secured dignity and equality to women, not making them subservient to a husband or his consent or on that footing. However, my lords, to say that what they are trying to make out probably is that culling out or classifying army wives, their submission in the application is quite shocking. They say that army wives are living separately in in separated family quarters, and their husbands, their officers are at the border. So the husband should not have insecurity in their minds that their families are dealing with undesirable actions. Well, this is an affront to any army wife. In fact, me being one.
No, it's not applicable to army wives. So.
Absolutely. And that the
I
context.
may also point out, I may also point out, Lord, more explicitly, but a review petition was filed.
Let her make the submission.
Well, because if my lords just reads the contents of this application, they are actually the prayer may be very.
Why do you say it's an affront to the?
Because they just read one paragraph, my lords.
You can tell us in your own words.
Yes, sir. What they say is to ensure that all personnel perform their duties without unnecessary concern for their families. There is a system where frequent visits to families living away from their spouses by officers, JCOs, is a regular feature. In view of the aforesaid judgment, there will be always a concern in the minds of the army personnel who are operating far away from their families under challenging conditions about the family indulging in untoward activity. Well, is this paragraph and also some.
See, it's only concerned with the army officer involved.
So,
If the concerned lady or a male
absolutely.
is having a relationship with a person who is not an army personnel,
That's right, my lords.
that is not prohibited.
Absolutely. So what happens is, where do they draw the line? If an army wife.
An officer gives a complaint.
Just hear their question, please.
Why do the officer gives a complaint that he's having an affair with somebody? Or you're talking about the adultery being committed by the wife, isn't it? It's wife of the officer.
Not in this particular case, yes, that we are talking about, yes, we are talking with another officer. With another
Another officer.
officer. In this case.
No, in the event the lady is the officer and
Both, it's gender neutral. Our action will be absolutely gender neutral. in that sense.
But in
So,
that-
my lords, I just want to say that please do consider, because your lordships are taking up these matters, because this may, what has happened is, and that's why, my lord,